Understanding the rules of evidence is essential for anyone involved in a legal dispute. These rules determine what information can be presented in court and how it should be handled. There are basically 6 types of evidence. Direct evidence. This is evidence that directly proves a fact, for example, eyewitness testimony or a video recording of the incident. Number 2, circumstantial evidence. This is evidence that suggests a fact by implication or inference. For example, fingerprints at a crime scene. Then there is real evidence, which is physical objects presented for inspection. This can include weapons, documents, or clothing. Number 4, testimonial evidence. These are statements made by witnesses under oath. This could be both oral and written statements. Number 5, documentary evidence. This is, as the name suggests, written or printed materials, documents such as contracts, emails, medical records, etc. Number 6, demonstrative evidence. This is something that demonstrates or illustrates a point, such as charts, maps, or models. There are 5 key rules of evidence. Number 1, relevance. Evidence must be relevant to the case. It should make a fact more probable or less probable than it would be without the evidence. Example, in a theft case, evidence showing the defendant's financial difficulties might be relevant. Number 2, the hearsay rule. Hearsay or out-of-court statements used to prove the truth of the matter asserted is generally not admissible. There are exceptions, but generally it's not admissible. So, a witness cannot testify that a friend told them that they saw the defendant at the crime scene. Number 3, authentication. Evidence must be authenticated, meaning there must be proof that the evidence is what it claims to be. So, to admit a photograph, for example, a witness must testify that the photo accurately represents the scene or a person or whatever. Number 4, the best evidence rule, which says that when the contents of a document are in dispute, the original document must be produced. For example, if the terms of a contract are in dispute, the original contract must be presented rather than a copy. Number 5, exclusionary rule. Evidence obtained illegally, such as through a violation of the Fourth Amendment protection against unreasonable searches and seizures, is generally inadmissible. In Mapp versus Ohio case, for example, evidence obtained from an illegal search was excluded from the trial. Now, if you look back at the O.J. Simpson trial, the prosecution presented DNA evidence linking Simpson to the crime scene. Despite the scientific validity, the defense cast doubt on the evidence by highlighting potential contamination and mishandling by law enforcement. Then there was the glove evidence, which was when Simpson tried on gloves found at the crime scene. The defense argued that the gloves did not fit, leading to the famous line, "If it doesn't fit, you must acquit." emphasizing the importance of directly demonstrative evidence. There was also some hearsay evidence that the prosecution tried to introduce, which were statements made by Nicole Brown Simpson to friends and family about OJ's abusive behavior. These statements were argued under the hearsay exceptions but were met with resistance from the defense. The trial showcased the complexity of applying evidence rules and how effective legal strategies can shape the interpretation and admissibility of evidence. To learn more in depth about the legal system and how you can represent yourself, please go to the description below and click on my affiliate link. If you're watching this on TikTok, please contact me via DM. Thank you for watching.